Action SA is taking the IEC to court after being left off the ballot papers for the local government elections. It's not the first time the parties butted heads with the IEC. The Commission previously rejected Action SA's application to register as a political party. For more on this, I'm joined by Tselane, the Executive Chairperson of the Institute of Election Management Services in Africa. So Terry, what's your view? Should Action SA's name be left out because they failed to fill in a section asking for an abbreviation?
Well, good evening to you. Section 15 of the Electoral Commission Act requires a party that wants to register to submit certain documentation and information in a particular format. That information includes the name of a party, the distinguishing mark or symbol, and that must be in color, the abbreviation, if any. And then once that has been satisfied, the Chief Electoral Officer will then register that particular party. But before they do that, they will submit to the political party a registration certificate and then also submit that information as submitted by the political party in a government gazette. They will issue that information in a government gazette. So a political party or any person who wants to object has got an opportunity during that particular period to correct the details thereof. That's what the law says. And then therefore, by the time the elections have been proclaimed, that requirement of Section 15 has already been met, and therefore it is expected that the political party that would be contesting would be represented by information that it supplied when it registered as a political party.
Okay, so Action SA is saying in its court papers, and I'm quoting it here, the Electoral Act does not require a party to have an abbreviated name, and the Commission bases its decision on the fact that Action SA did not register an abbreviated name, even though the Act does not require a party to have an abbreviated name. You're saying that's not a sound argument in this case?
Well, let's focus what the law says, and then we only focus on Section 15 of the Electoral Commission Act, which determines the requirements for a political party to register as a political party. That provision requires a political party to submit amongst its information appreciation, if any, of that particular political party. So it means there is an option for a political party, if it does not have an appreciation, not to submit information in that regard. Now, when you look at the information that was supplied on the 27th of November, which information was published in the government gazette of that day, in the section which requires an abbreviation, it says not applicable. Now, not applicable means that there is no abbreviation. Now, the Electoral Commission can only work on the basis of the information that is provided by a political party. Now, in this case, where there is no such information, the Electoral Commission cannot mine that information and put information of its own in the space that has been left blank by a political party. So they've got to work on the basis of what they've been provided with by the political party.
Okay, why couldn't the IEC just contact the party to query such an important piece of information? Surely when forms are filled in right, anywhere, regardless of where it's filled in, when there's something that doesn't look right, picking up the phone isn't hard to say, you might have gotten this wrong. Why are you saying not applicable?
Yeah, of course you are correct that perhaps officials in working with within the Commission that are dealing with the registration of political parties should have notified Action SA and all other political parties that have registered but had not actually included this information to say that there seems to be information missing here. Is this the way you want it to be reflected, or is this a mistake on your part? So that, you know, all the details are provided for. But that, of course, is not an obligation on the part of the Electoral Commission or its staff. A political party has an obligation also to check all those details and to make sure that the information that it supplies is accurate. The only obligation that the Electoral Commission has is in terms of Section 16 of the Electoral Commission Act. And that's where there is an obligation on the part of the Chief Electoral Officer to make sure that whatever information that has been supplied to by a political party is not confusing to the voter with its information being similar to any of the political parties that are already registered.
Yeah, I get what you're saying. I still think it was, something that they should have done. So is it too late for the IEC to correct this? If a court happens to rule in favor of Action SA, what happens then?
Well, I think the train has left the station. But if the court rules in favor of Action SA, of course, the Electoral Commission has got an obligation to make sure that it complies with the court order. It will not just proceed with the elections as though there is no such court order that is favorable to Action SA. They will have to think about Plan B just in case Action SA succeeds in its argument. You may recall that in 1994, the same thing happened with regard to eNCA, the Freedom Party, when eNCA, the Freedom Party, had actually been left out of the ballot paper because they did not want to participate in the elections. And within or on the 11th hour, they were able to get that information through a sticker. So the Electoral Commission, even though it proceeds with the printing of the ballot papers, because it has to continue to make preparations for the elections by printing the ballot papers, it will have to think about Plan B, just in case this eventuality is there, where now they are required to close that space with the details of Action SA so that the election can still proceed on the 1st of November. Because there is no way that the elections are going to be postponed. The Constitution requires the Electoral Commission to have the elections on the 1st of November. And the Constitutional Court has also ordered that the elections must take place by the 1st of November. So the Electoral Commission has got absolutely no option but an obligation to make sure that the elections happen on that day.
All right. Thank you so much for your insight. Always a pleasure talking to you. Tselane, the Executive Chairperson for the Institute of Election Management Services in Africa.